I'm going to try to make this a quick video. The dog's tummy is rumbling. He's going to have to go poop soon. There's three comments that are typical, so I'm going to use them as jumping off points. First one's by Pied Piper, who references common law and common law judges. Courts and judges are defined by statute or constitution. So state constitutions will set up courts, state statutes will set up courts, the Constitution will set up federal courts, and federal statutes will set up other federal courts. So there aren't any common law courts, common law judges anymore. Common law is also pretty much gone. If you look, there's Erie v. Tompkins. Erie v. Tompkins is from 1938, and they held that there is no federal general common law. So bad elk is out the window. There is no federal general common law that says that you can resist unlawful arrest up to the point of killing the police. So sorry to break your heart. I know a lot of people were really hoping that they could resist unlawful arrest up to the point of killing the police, but no, that is not a thing because there is no federal general common law. That and bad elk was only applied to Indian Territory, and the common law of Indian Territory was replaced by the 25 CFR. States have, however, also gotten rid of common law. This is New Jersey. They have abolished common law crimes. California has abolished common law crimes. So no act or omission except as prescribed or authorized by this code or by some statutes or by ordinances, municipal, county, or township regulation, passed or adopted under such statutes as and blah, blah, blah. And this has been in effect since 1872, so California has not had common law crimes in forever and a day. Texas is very similar. This is Texas Penal Code 1.03. Conduct does not constitute an offense unless it is defined as an offense by statute, municipal ordinance, order of a county commissioner's court, or rule authorized by and lawfully adopted under a statute. Now, before you get all excited and see the word court there and think that this is a judicial body, it is not. It is an administrative body. There is a judge on the commissioner's court, but there's also 4 regular old commissioners, and their role is to perform administrative functions for the county, like determining county tax rates and etc. Second comment I wanted to address is along the lines of this. You're aware the charges were dismissed for lack of evidence. Other things I've seen is people ask me why the police aren't enforcing the CFRs when people go into film in a post office. And there's a couple of things that come into play there. First of all, like for Olmos Park, where Jack, Texas Sheepdog, was arrested for having the round loaded in his rifle. That would be silly to prosecute for a lot of reasons. It was against the law, but that would have been silly for the prosecutor to prosecute because, number one, it would have been a tiny fine. Number two, the city council had already removed that ordinance, so while he could still be prosecuted under it, that ordinance is no longer in effect, so why prosecute it? And the third thing is that there's a high likelihood of A, an appeal, and B, losing on appeal due to that statute being preempted by state statutes and the state constitution. So it would be silly of them to do that, to go after a $500 fine and face potentially tens of thousands of dollars in appeal litigation and things like that. Also, police barely know local ordinances and state statutes, and expecting them to know the nuances of some 300,000 criminalized activities in the Code of Federal Regulations is asking a lot of them. If they even have jurisdiction to enforce federal crimes, they may not have jurisdiction depending on the state, depending on whatever the peace officers are authorized to do by that state. They may not have authority to enforce federal crimes. Now, does that mean that you get away with it if the police don't arrest you for it? No. For example, if you violate the 39 CFR 232.1, a postal inspector could get an arrest warrant for you. Remember, people are posting these on YouTube. There is a video record of them committing these various crimes. So yeah, until statute of limitations runs on them or whatever, if somebody really got a burr up their ass, they could go after you for it. I'm not saying that they will. My role in this is to educate you on what is or isn't a crime, not to say what will or won't be prosecuted. There's political reasons that prosecutors might not want to prosecute. Police and prosecutors have discretion as to what they arrest for or what they charge for. So I can't read anybody's mind. I don't know ahead of time what they will go after. And there are a lot of stupid people in the world, like where Padilla was charged with failure to identify and not trespass. That was just retarded. I can't account for retarded people in positions of power. That is beyond me. I'm not God. I can just look at the statutes, look at case law, figure what is or isn't a crime, and educate you on that appropriately. And the third comment is there's a difference between and or. And they want to say or auditoriums, not and auditoriums. Well, so there was a time and a place where and or are meaningful. Like if you remember in this Colorado Code 18-4-201 talking about trespass, a person who enters or remains upon unimproved and apparently unused land has license and privilege. If they change that to unimproved or apparently unused land, then you'd have license and privilege on unimproved land, and you'd have license and privilege on apparently unused land. So what this does is this narrows it. This and is meaningful here. In this sentence, or this is a sentence fragment, but I'm going to read it as a sentence. Photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, or auditoriums is substantially the same as photographs for news purposes may be taken in entrances, lobbies, foyers, corridors, and auditoriums. What difference there is, I'm not a grammar Nazi, or at least not enough of one to really care. And courts aren't going to be either. A court's going to look at the sentence and they're going to get the idea of what this sentence is trying to do. This is trying to define what activity, photographing, for news purposes specifically, is allowed in what spot. So photographs for news purposes may be taken in entrances. Photographs for news purposes may be taken in lobbies. Photographs for news purposes may be taken in foyers. Photographs for news purposes may be taken in corridors. Photographs for news purposes may be taken in auditoriums. They're going to look at that and they're going to read it just like that. They don't care about the or. They're not going. It doesn't change the function of that sentence, or at least not in a meaningful way in the commonly used vernacular in America. And if you think otherwise, I'm sorry, you're a better English student than I am. Congratulations. But a court isn't going to take any argument on that seriously. The court's going to look at this. They're going to determine the plain meaning of it. And they're going to say, well, yeah, that means you can photograph for news purposes in entrances or lobbies or foyers, or corridors or auditoriums. You couldn't do it all at once, so putting an and in there doesn't change anything. I hope that makes sense. Anyway, so I hope I've answered some questions, some commonly asked questions. Consider this like a fact. But if you have any more questions, or if you feel that I've neglected something, or if you think that I have done a poor legal analysis or something, please let me know. I do read comments, and I do enjoy interacting with this community. And I am an OG troll. Yeah, buddy. Take care.